They didn't read me my rights. I hear that one a lot, and what people are talking about is the police not reading them their Miranda rights. And I think what most of the public thinks is that if the police don't read you your rights after they've arrested you or before they've arrested you, that their case should be thrown out or that their evidence should be thrown out. And that's because the media doesn't do a very good job of truly explaining what your Miranda rights are. What your Miranda rights are come from a case called Miranda versus Arizona, where the United States Supreme Court found that there were too many times where police were getting confessions or statements out of people while they were tricking them in order to do it or pressuring them in order to do it. So the Supreme Court said, look, before the police are going to interrogate somebody after they have somebody in custody, they have to give them a series of warnings. They have to tell them that they have the right to remain silent, that anything they say can be used against them in court, that they have a right to a lawyer present during questioning, and that if they cannot afford a lawyer, that one will be provided for them by the court. And that's essentially what your Miranda rights mean. And in most situations involving the police, your Miranda rights don't even come up, and that's because either the police don't need your statements in order to get evidence against you, or they trick you into basically giving a voluntary statement, or they don't even have to trick you. Some people just voluntarily give statements against their own interest, which can hurt them in court. So let's go over that. First of all, for your Miranda rights to trigger, in other words, for the police to have to give you the Miranda warning, two things have to happen. One, you have to be in custody, and that means in police custody. And the second one is that it has to be an interrogation where the police are actually asking questions in order to get you to try to confess to something or to try to give them a response. So if you're voluntarily saying things, even if you're in custody, if you're voluntarily blurting things out but they're not asking you questions, then that's not an interrogation. Also, if you're not in custody, in other words, if you're free to leave and so forth, then even if they're interrogating you because you're not in custody, your Miranda rights are not going to apply. When the court looks at whether someone's in custody, they look at a series basically of 6 different factors. The first one is whether the encounter that you're having with the police is voluntary, and whether they've told you that you're here on a voluntary basis, that you're free to leave, or that you're free to terminate the encounter with the police, and that you're not under arrest. That's the first thing they look at. The second thing a court looks at is whether you have unrestricted freedom of movement in whatever room that the police are questioning you in. The third thing that they look at is whether you, the suspect, initiated that contact with the police or voluntarily appeared for questioning. The fourth thing is whether the police are using what are called strong-arm tactics or trying to trick you into giving up your Miranda rights. The fifth thing is whether the atmosphere is police-dominated. And the sixth thing is whether after you make your statements, whether the police placed you under arrest. So this is a fight that comes up in court a lot when we as criminal defense lawyers have a client who gave a statement that's harmful to them. We'll try to get that suppressed, and we'll argue when it applies that was a custodial interrogation and that the person wasn't given their Miranda warnings, and therefore that the statement should be suppressed and not used against you. Some common tactics that police will use in order to get around having to give you the Miranda warning and be able to use whatever you say against you is things like this. One thing they'll do is call you up on the phone, and they'll say, look, someone made a report against you and we just want to get your side of the story. And we're investigating this, but we just want to get your side of the story. We're not arresting you. We're not charging you with anything right now. But what's your side of the story? If you talk to them over the phone, it's clear that you're not in custody at that point, and so anything you say will be used against you. And while sometimes the police are really trying to just get your side of the story, more often than not they're using that as a tactic to get you to make certain admissions or say certain things that they can then use against you when they charge you with a crime. And they're often taking notes during that telephone call or actually recording it. And a lot of times they don't have to inform you that they're recording that call. So that's one thing to watch out for. Another common tactic the police do is invite you to come down to the police station, and then you come down there voluntarily. Like I talked about, one of those factors is whether your encounter with the police was voluntary or whether you initiated contact with the police. And by coming down to the police station and agreeing to talk with them and meet them there, That's usually a voluntary situation, so again, you're not in custody, and therefore they don't have to give you the Miranda warning, and anything you say will be used against you without that Miranda warning and without a lawyer present. Other things that they'll look at, for example, if we've got somebody where the police will come to your home and maybe they'll corner you in your bedroom and they're questioning you right there because they're responding to a domestic abuse call or a report of drugs or a fight or something along those lines. Sometimes you're in custody when they're doing that, even if they don't handcuff you and even though you're in your own home, and other times you're not. It depends on a whole bunch of factors. So this is one of the situations that are often fought about in court between defense lawyers and prosecutors, and that is whether or not what you said to the police can be used against you. So the best thing to remember is that you don't want to talk to the police if they initiate contact with you. If they really just want to get your side of the story, they'll let you do that even when you have a lawyer. So the best thing you can do is say, look, I might talk to you guys in the future, but I don't want to talk to you without first seeking the advice of a lawyer or without a lawyer present. And if you specifically stick to your guns and you say, I would like a lawyer present before you question me, then the police won't ask you any questions. Sometimes they'll still charge you with the crime because they've got enough evidence anyway. That's fine, because you haven't made your case work or your case worse against you by saying things that are only going to hurt you later. Other times, without you saying anything, they don't have enough evidence to charge you. So it's always, or 99% of the time, it's best not to talk to the police. What I would suggest is that before you make that decision whether to talk to the police or not, you take a moment to get a hold of a criminal defense lawyer and find out whether or not you can get that lawyer present, or whether, under the facts of your case, it's safe for you to talk without a lawyer present. Otherwise, you risk having anything that you say used against you, even if the police seem like they're just trying to get your side of the story. If you have more questions, feel free to give me a call. My name's Ryan Pacyga. My number is 612-339-5844, and my website is www.arrestedmn.com.